We have all thought that at least we have the sanctity of the privacy of our innermost thoughts and feelings. And with these new technologies, that might not continue to be the case.
Welcome to Privacy in Practice, the podcast where we bring you the latest insights, practical solutions, and real-world stories from the world of data protection and privacy. I'm Kellie Dupree.
And I'm Danie Strachan. Privacy in Practice is brought to you by VeriSafe, your trusted partner in privacy and data protection. In this podcast, we dig into the challenges and opportunities in privacy compliance, from navigating complex regulations to building a sustainable privacy program that works for your business, not against it.
So let's jump in and get practical with privacy.
We're excited to welcome Kristen Mathews to the podcast today. Kristen is a partner at the global law firm Cooley LLP. She has a long-standing practice in privacy and cybersecurity and has helped many clients navigate challenges around cutting-edge privacy issues as they evolved.
Kristen was at the forefront of navigating many emerging privacy issues, including ad tech and AI. So she is no stranger to nor scared of an emerging privacy area, which is very lucky for us since we'll be talking to her today about the new and sometimes scary world of mental privacy. She is also a long-standing member of the IAPP and has been a certified privacy professional since 2005.
Kristen is consistently recognized as a leader in privacy and AI by Chambers, Law Dragon, the Legal 500, just to name a few. And she's also actively shaping industry standards as a board member of a nonprofit focused on ethical AI.
We are thrilled to take advantage of Kristen's expertise and her passion for the emerging world of mental privacy. Kristen, welcome to the show. It's a pleasure to have you. I'm really excited for our conversation. I think it's going to be quite an enlightening one. First, can you tell us a little bit about your journey into privacy?
Absolutely. I have been a specialist in the privacy area for a very long time, my whole legal career. And as a result, I have seen quite a bit. I've seen a lot of evolutions of privacy laws kind of come and become very important and get dealt with and then kind of fall by the wayside. I've seen many new products emerge that have various sorts of privacy issues associated with them. For example, I was involved in the early days of online behavioral advertising. I was involved in some of the first data breaches. In fact, I helped a few companies with data breaches before they had to do anything, before there were any laws that required them to do anything. But yes, so also biometrics, when individuals started to share voluntarily their biometrics with governments and companies. I've been watching the rise of the surveillance state for a long time, my whole career. So having watched so many different things happen over the course of my career, it has enabled me to see a macro view of how privacy issues have evolved over the last few decades.
I want to get to the basics as a starting point. When data subjects engage with platforms, with services, with apps, there's invariably an exchange of data now. And it's challenging for privacy professionals and for people that manage these platforms and tools and apps how to approach data privacy. You have laws across the globe that are now tackling this issue. But I've read that you have an interesting unifying theory of privacy. Can you tell us more about this and how to approach this?
Because I've been watching this for so long, I have like a unique kind of distant perspective of it, a macro perspective. And I'll tell you what that has enabled me to see. So anytime a person decides to use a service, a new service, there is inevitably going to be an exchange between the person and the business that offers the service. Now, that exchange may or may not be money, and that's kind of irrelevant for a privacy conversation. But if it's an online service, then there is almost certainly going to be an exchange of the person's information. Now, some of the information, the business that provides the service needs it in order to provide the service. It's a necessity that they receive and use this information. But sometimes either of two things happens, or both. The business does receive that information that they need, but they use it for more than that. They use it for additional purposes. And then the other thing that can happen is that the business collects more than they need in order to provide the service. So that's the data exchange that a consumer enters into anytime they use an online service. And on top of that, privacy laws are all based on a tenet of a reasonable person's expectations. You might have heard this term used a lot. What is the reasonable person's expectation of privacy? What would they find creepy? What could happen that they didn't expect to happen with their data or with their privacy, but that if they find out later, they wouldn't be happy. They would feel that they should have known. So that's where transparency comes in. And almost all privacy laws out there across the globe have maybe as their first tenet is transparency, meaning that people have the right to know what a business is doing with their information that's outside of the expectation so that they can make their own decision about whether to use the product or not. And for a long time, the method that we've been using to achieve transparency has been by posting privacy policies. And the problem is that people don't read privacy policies. And so transparency isn't really being achieved by the use of a privacy policy. And when people don't know what's going on and they find out later, they're disappointed and they feel cheated. And that's what leads to litigation, which hurts everybody. It hurts the business and it hurts the consumers and it hurts the world. So when something is important enough, it warrants a more front and center version of transparency.
I think that's fantastic. I don't know how many times any of you have had the experience of being in a social setting and somebody asks what you do and you say you're a privacy lawyer and they say, oh, are you the one that does the annoying policies and the cookie pop-ups and stuff like that? I think you're quite right that the privacy notice has a limited, increasingly limited utility. It's certainly a wonderful legal document, but it doesn't necessarily achieve the purpose that it is designed to achieve. But maybe it could. I think that's kind of the next set of questions here.
Yeah, I mean, I'm quite curious in your experience, Kristen, to learn about situations where this has worked well. You don't have to mention specific examples, but situations that you've seen where a platform or where an app has addressed this properly and made it user friendly to achieve the best transparency.
There's a bunch of things I see when it's done well. One is when the data exchange, which is what we're going to call it, is explained in the user interface when the user starts using the services. So yes, there's a privacy policy also, and that's where the details are. But when the user begins and decides to use the service, these core aspects of the data exchange is presented to them there at the time and place where they make the decision. So they're given the information at the exact time that they need it. And actually the words time and place is are words that you sometimes see in privacy laws. Maybe it would be on a landing page, or maybe it would be on a registration page. It might be in the first pages of an app if that's the context. The other thing that seems to make this go well is if the wording of this information matches the voice of the rest of the service, because every service has a voice that it speaks to its customers in. And oftentimes you'll see that the privacy notices are written in a different voice. They're written in a lawyer's voice, or at best a businessy voice, but rarely in the same voice as the rest of the services worded in. And I think it works better if these particular notices are put in the same voice as the service, because that's what they're going to read. And also of importance is that these sorts of presentations not be too wordy. Obviously, it's important that they not only be buried in terms and conditions where somebody has to read through it to find it, but also presented front and center in front of the user.
Any practical ideas about specific categories? So senior citizens, people that aren't first language speakers, children. Any practical advice for listeners how to approach those more difficult situations?
I will say that it is actually very difficult to convey important information like this in wording that's intended for a young person. Oftentimes you'll see them say that the wording should be in the language of I don't know what grade they say, sixth grade reader. That is extremely difficult to do and to also convey the information that's important for them to know. So it is definitely a challenge. I think short sentences are helpful. And also you can say it briefly in the voice of the service, but then link to the details that are in the bigger, more detailed privacy policy.
I think something we talk a lot about is putting yourself in the shoes of the data subject or your client or something else. And I think that's a lot of it too, is which words you pick to put in it. In order to make it short, you have to really think, what do they care most about? What are they going to be most worried about? What are they going to be, as you said, I love that word creepy. Like, what are they going to be creeped out about? Like, what's going to concern them about your practices? Any advice about how to figure that out? I mean, maybe it should be obvious. Maybe that should be an obvious thing. But I think sometimes when you get so in the weeds of a business, you yourself are an in-house component of the business or you're helping them as an outside counsel. How do you kind of work through what you think a consumer might most want to know?
That's another challenge because what people think is creepy is a moving target. The things that everybody kind of were creeped out about 5 years ago, they're not creeped out about anymore. So that's one reason why it's difficult to spot these things. But the other reason why it's difficult to spot them is because the business owners, the ones that are building these products, they're different from the rest of the world just because of the business that they're in. And it's not creepy to them at all. They are so normalized to it. But, if you start talking with the average person, their perspective might be different from the person who's developing a newfangled app.
Yeah, awesome. I think also I think sometimes if you have a consumer-facing app, the member team, the customer team, the whatever, it's always interesting to hear their thoughts on what kind of emails they get, what kind of complaints they're hearing. But ideally, you don't get there. Ideally, you address it before it gets to that point in the first place.
The other aspect of transparency that's important to think about is that sometimes services or apps or products collect or even derive information about the person that isn't apparent to the consumer. I mean, obviously, they know what data they're giving proactively to the business, especially during registration. They're typing information into a form of some kind, but they might not realize some of the data that the business is getting to them after that in the course of their use of the service or deriving from all of that information. And so that's something that it's important to be transparent about because that's what's going to surprise them.
I think what's also interesting is to not underestimate your data subjects because I'm often involved in running of sweepstakes and contests and the like, and typically people's personal data is collected in the process. So you always see these long terms and conditions, and there's a privacy policy, and you always assume people just want to win the prize, whether it's a sweepstakes or whatever they have to do to win a prize in a contest. You think that they'll just check the box, but it's interesting to me that people actually do think about this a little bit more. I've been involved in more than one project where you'll be surprised at the number of data subject rights requests that you subsequently receive, which I think is a good indication. It means that people are actually getting these notices. Maybe they are very complicated because sometimes those data subject rights requests say, I see you processing my data. I'm actually not really comfortable because I'm confused. Can you explain this to me or please stop? So I think it would actually be interesting to do a study about that one day and just sort of see how effective are these notices. Are people confused by them, or do they actually take the time to read them properly and understand them?
Well, I mean, on that note, I will have to say that the more front and center this presentation of the terms is, the more people will read them. And so there might be a need for businesses to convince them that they're getting something in exchange for all of this. They're enabling the business to improve the product for them and for everybody.
I think that I like the data exchange. I like your phrase a lot because I think that's correct. I think that it can be scary sometimes for businesses to think, hopefully they don't feel they're doing anything creepy, and that's not why it's scary to them to disclose what in fact they are doing. But sometimes you get people who are concerned about how much transparency or what kind of transparency or the way in which we overwhelm people with information. I think that's a good way of phrasing it. It's don't underestimate your data subjects, give them the information they need to make an informed choice, and then they will be better users of your product. They'll be more informed, and they'll probably be less likely to sue you later or submit a data subject rights request or a variety of other things, complain to an EU regulator. It is a data exchange, and thinking of it in those terms is a really nice way to make everybody an adult in the conversation.
Anytime you hear the word transparency, you usually also hear the word choice. Like notice and choice, they come together. And we haven't really talked about choice yet. So the other aspect of this is that if the business is going to use the data for more than just providing the service that the person requested, but in addition to also maybe use it for some additional purpose that's beyond the expectation of the user, then choice would give the users the ability to either opt in or opt out of that.
I think that's a really important thing for people to consider as they are building products that might have additional information. On that note, I want to talk about the Internet of Things quickly. I mean, let's think about that situation. We've got like an appliance in a house that we all know now, speaking of consumer expectations, can collect information, or most people now know that. What are some of the ways or places you could communicate some of this data exchange in a functional way or in a clear way outside of the legal privacy notice?
Well, I mean, this does present a challenge for transparency because, well, at least my smart refrigerator and my smart microwave doesn't have a visual interface where I can read words. But So therefore, there's no opportunity on the appliance itself to show me a written notice. So there's a challenge there. We need to find a place to let people know what's happening with smart appliances or any kind of IoT. But there's usually an app associated with a smart appliance, and the app presents a place where the user can be informed of what's happening.
I'm just curious, some of these devices, I think mine has the option to do all sorts of clever things if it's connected to the Wi-Fi, but I just feel that some manufacturers should draw this to consumers' attention a little bit better, because if you download the app, you might get the privacy notice there, but some of these devices already collect some data, even with you not having downloaded the app. Smart speakers and definitely home appliances. I think some people do connect them to the internet so that it can update the clock or whatever, but they don't realize that at that stage things are happening.
I would wonder about the user manual or the box. By the way, before you plug this thing in, it's part of your quick start guide.
By the way, I have seen privacy notices on boxes.
Thinking about getting this information across. So if it is on the box or if there is a label on the appliance, do you have any tips for doing this when you're short of space?
Well, remember, these notices are not supposed to be written in legalese or even businessese. They're supposed to be written short and sweet. So that's our desire anyway. Now, of course, you're not going to be able to get all of the important information in a very short sentence, but there's always the opportunity to link to something with more detail.
I think it is tricky to think of how to do it in a nice, clean sentence or three. That's, I suppose, the challenge.
So we've been talking about all sorts of interesting devices like your microwave and your smart speaker, but what about wearables, earbuds, things that people put in their ears without sort of any screen? I mean, yes, maybe it might have an app, but what are the privacy issues there?
Good question. So wearables are unique. And they're capable of collecting more data about us than we realize, because they're physically touching our bodies. And so they can collect our biometrics, our temperature, our heart rate, and other things like that. And this sensitive information warrants heightened transparency. And more recently, technologies are being developed that can almost read our minds. And that's the last frontier, right? I mean, during all of this, we have all thought that at least we have the sanctity of the privacy of our innermost thoughts and feelings. And with these new technologies, in some number of years, that might not continue to be the case.
what I hear you talking is this concept of mental privacy. And this is a fascinating thing that I was just saying you've brought into my life, Kristen. Tell us about it. What is mental privacy?
Well, there are technologies that are being developed and in some cases already on the market. Some are implanted into the brain, but others are just worn, like maybe headbands, earbuds, helmets, the like. But either way, they detect electrical activity from the brain and derive information about that data. Like, for example, do you recognize what you're looking at? Have you seen the murder weapon before? Do you like what you're looking at? Are you paying attention? Are you responding well to this argument? Are you responding well to this advertisement? So many different things that can be derived. Some of this is in development from your mental data, and all of them present obvious privacy issues. And that's where mental privacy comes in.
So I've seen different terms being used by different people and in different jurisdictions. So a common one that I've seen is neuro rights. And I think it's the concept that they're trying to convey is the fact that we as humans have rights over our brains and our own mental space, and that we should have mental autonomy and mental integrity. So I guess if you had to define this in a different way, it's our right to keep our minds sacred and decide what people should be able to pick up from our minds, I guess, but also what people should be able to put into our minds. Because I think some of this technology, which is hopefully still far in the future, will be able to, in some kind of subliminal way, convey some kind of message to you while you're focusing on something else or while you're sleeping or whatever. Tell us about the laws. Where are we at? Because, these things sound scary. I'm hoping that legislators are also scared about this. Have they cottoned onto this, or are they doing something about it already?
So I think the reason why people who find out about this are reacting the way they are is because the data that comes from our brains is inherently more sensitive than other data about us that we've always thought of as sensitive personal information, like social security numbers, financial account numbers, even medical information, race and ethnicity. Those are the kinds of data points that we've always identified in laws as sensitive personal information. But when you start looking at our actual brain data, that's like our source code. So it's more sensitive than what we're typically covering. So there are some laws already, but very, very, very early. These are early laws. So Colorado and California both amended their consumer privacy laws last year. And what they did was they simply added neural data to their definitions of sensitive personal information. So they basically say that data from the brain is, quote, sensitive personal information, and therefore it needs to be protected just like the other sensitive personal information. But what those laws didn't do was think about what might be different for mental data and what more protections might be appropriate for mental privacy.
So with the EU AI Act, we see prohibited categories of AI, including things like subliminal messaging, to your concern, Danie, or prohibiting social scoring. But again, it's not a mental privacy law. It doesn't talk about why this data exists, how it's collected, how it needs to be protected. It just talks about ways that you can't use AI with it. I wonder if you see any trends in how you would like the laws to address this, or if you see sort of where this ought to go.
So if we're trying to design a law that would be appropriate for this kind of data, first of all, you would grab whatever the laws say about sensitive personal information and, enhanced notice, consent. I can walk through some of the things that are required generally for sensitive personal information if you're interested. But maybe layer some things on top of that. Like, for example, consider storing this kind of data, neural data, locally on the device rather than in the cloud somewhere or someplace where the provider can access it. Have it be encrypted in storage, maybe even have it encrypted in a way such that only the individual's device can decrypt it and not the business itself. Now, give people choice with regard to the use of their neural data for purposes beyond providing them the service that they actually requested. Now, let's also talk about de-identification. A lot of businesses kind of get around laws by simply de-identifying data in order to make it not personally identifiable and therefore able to use it for what they please. Think about whether that's even possible for neural data. And also think about whether and how to future-proof your de-identification method so that the data will be effectively de-identified today and also in the future.
Another thing we didn't talk about is that intersection with AI and mental privacy, because I think it's very hard to use the data without using AI to analyze it.
So AI comes into play when the neural data is detected and recorded, if you will, from the brain. But the data is so vast that there's nothing that really can be done with it that's useful unless you apply AI to it.
Which, this stuff is so complex. It's so complicated. There's so many different regulations that need to be considered. And, do you come at this from an AI angle? Do you come at it from a mental privacy angle? Do you come at it from its own regulation? I think a lot of questions to be answered, but I think it's important to consider the implications of all the things that are problematic in AI, whether that's bias or, we're talking about whether these neural pathways are unique signatures. If there's bias in the AI that's analyzing them, how does that impact you? Does that impact, the treatment? If it's something related to anxiety, does that impact the treatment that you're getting from your wearable device to help soothe your anxiety if it's using the neural pathways of men and you're a woman or something to that effect? I think, who knows? Lots of questions for these companies to consider.
So traditionally, when you have personal data and you want to try and find ways to protect people's privacy more, you either try and de-identify it or you use other kinds of technologies, so differential privacy, all the other kinds of sort of traditional methods to enhance people's privacy. But when it comes to your brain, I'm just wondering if there are any new privacy-enhancing technologies that are specifically dedicated to protect your neuro activity, to enhance biosecurity, so to speak, or is this a field that needs to be developed if no one is looking at this yet?
So maybe you can put aluminum foil over your head. I'm just kidding. I actually do not. I think it's too early. I mean, this is so new that people are only now thinking about it, much less creating products to protect it.
What should consumers be thinking about as they're, we were just chatting about buying earbuds, for example, buying Internet of Things devices or wearable devices or virtual reality headsets. How should we be considering this as individuals as we navigate the very cool products in this space?
I think they should realize how sensitive neural data can be and seek to find out what the data exchange is when they decide to use a Neurotech product.
This ties back in nicely to, the beginning of our conversation. So, as a consumer, you should be looking for clarity around the data exchange, right? That maybe it's in the privacy notice, maybe they've listened to our podcast and there's a nice summary of the data exchange somewhere easily accessible. I think that's kind of the takeaway for businesses as well. So maybe that's the next question is, now you're a business considering entering the space or investing in the space. I think you already gave some nice examples about the things that people should be doing to protect this kind of data. But as a business, what are some of the considerations that they should be having in mind as they're exploring?
I think they should design their products with respect for the sensitivity of neural data and make sure that their customers are told in a way that they can understand what the data exchange is when they decide to use a neural product. And when you tell them the data exchange, you might also have to show them why the data exchange benefits them by enabling the business to improve the product for them and for everybody else.
I'm curious as to your views on how some states or some countries are regulating this. So some of them are doing this on an opt-out basis. In other words, they are processing this neuro data unless you tell them to stop. Others say that you won't allow organizations to do this unless consumers provide their consent. What do you think is best when it comes to this? I guess it's a bit of an unfair question because this is up for legislators to decide, but opt-in or opt-out when it comes to neuro data?
My guess is that ultimately they're going to have to create categories of neural data and treat them differently, because there's the raw data that is detected from our brains. That's on one side of the spectrum. And then on the other side, there's information that has been derived from data, like they liked this product. And there's probably several buckets in between those two extremes. And I believe that ultimately when we're ironing out what are the requirements, the legal requirements for neural data, I think they're going to have to start bucketing neural data into categories. I mean, there's also a category of de-identified, so de-identified that it will never be re-identified. Maybe that's a bucket of its own where there's more flexibility for businesses. Raw data is a challenging category. I mean, that's really the new category, right? The raw mental data. I believe that there is a study going on where some researchers are trying to use neural data as an authenticator. In other words, as a fingerprint. So if that's possible, then raw data, maybe that's the extreme example of personally identifiable, if it's akin to a fingerprint.
That's exactly what I was going to ask, actually. You know, we think about like the genetic data, right? And everybody's sort of sending information off the 23andMe without potentially thinking through the consequences of a potential data breach or a variety of other things that happened. And obviously genetic data is a unique signature in many contexts and situations. Can neural data be a unique signature? It sounds like potentially it can.
Well, it's being researched. I feel that one answer to the question is to pick some buckets of neural data and store them locally. If they're stored locally encrypted, then the individual device can access it as needed to provide the service that they've requested, but they're not also accessible by the provider of the service, and therefore also not susceptible possibly to subpoena or to data breach.
Right, 100%. I mean, those have to be real considerations for the individual. You may trust the business that you've entered into a data exchange with, but there's other things to consider as well.
I'm interested in hearing your thoughts about self-regulation. So obviously, there are now states and countries that are trying to legislate around this. But one step before that might be for organizations to come up with their own code of conduct to approach this. Do you think that's feasible? What should those codes of conduct say?
I think that's exactly what neurotech companies should be doing. This is their opportunity. The time is now. And the time will pass when it will no longer be an opportunity. But right now, neurotech companies could self-regulate. They could design privacy protections for their products that make sense for their business, that are consistent with their business model, that also protect individuals. If they were to do that, it would probably stave off legislation for some amount of time because the legislators won't feel as big of a need to legislate because it would seem to them that the industry's doing it on their own. And on top of that, ultimately, when legislation does happen, it will be informed by self-regulation. And maybe self-regulation will actually mold ultimate regulation. So I think it would be a very wise thing for neurotech to self-regulate this now, maybe even in an organized way, like some kind of group industry self-regulation. And by the way, we saw this work a couple decades ago with ad tech. The beginning, I told you earlier that I was involved in the early stages of online behavioral advertising, and the ad tech space decided to self-regulate, and they gave people the right to opt out of behavioral advertising. And it actually did work because they didn't become encumbered by laws about this for many, many years later. And when those laws did come, they basically mimicked what the self-regulation had been.
I think what we've often seen is also that when it comes to self-regulation in whatever industry or whatever technology you're regulating, I think a typical way to approach that is to use the information principles that we've seen in the OECD principles, or the principles that are enshrined in the GDPR. But I read an interesting report from the European Data Protection Supervisor and the Spanish Data Protection Authority, where they mentioned some key challenges with applying the privacy principles to mental privacy. And two of the ones that stand out to me, the one goes to data accuracy. So one of the typical privacy rights is data accuracy. But if you're talking about neurodata, there's this concept of brain fluidity. So does your data in your brain remain accurate? Sort of, this is not, we're not talking about a hard disk or something where this information is coded. So it's going to be interesting to address the accuracy principle if you want to come up with a code of conduct. And then there are also issues relating to the volumes of data being processed, because one of the typical privacy principles, or one of the most basic ones, I think, relates to data minimization. So thou shalt not collect too much data. And how do you do that if the earbuds are in someone's ear 24/7? You're just collecting data the whole time, and it's extremely sensitive data and very, very large volumes of data. It's going to be interesting to apply that proportionality test to strike a balance between your purposes for collecting this data using the earbuds versus your obligation to collect as little as possible information. So good luck to the people that might be drafting those codes of conduct if they want to follow sort of generally accepted principles.
Let's end on a positive note. I think as privacy professionals, it's correct for us to be focused on protecting individuals and standing in the way of the misuse of data or the overcollection of data or all the rest of it. And certainly this is sensitive and important stuff. What positive things do you see in the mental privacy space?
So these technologies have wonderful applications that help society and help individuals. Like, as an example, the implanted ones that I mentioned that are implanted into the brain, they are being tested to be used for paralyzed people in order to improve their mobility and to communicate through computers. They have applications for ALS patients. They can predict seizures in advance. So if you're on the road, you can pull over. There's lots of medical sorts of applications for these technologies that are wonderful. Outside of that, they train people to meditate. They help people to deal with anxiety and stress. There's all kinds of very positive uses of these technologies. And I think we're going to use them and we're going to love them. I'm hoping that we get ahead of this with regard to mental privacy and protections that will make it a win-win-win, a win for the businesses, a win for the users, and a win for society.
And you can see, I think that's such a great way to end it. And you can see businesses having great opportunity in that space if they respect the self-regulated code of conduct, they consider the implications, and they implement a lot of these ideas of yours, Kristen, in terms of the encryption and storing it locally on the device and clarifying the exchange of data and all the rest. I think, it's important to consider the path forward, but possibly there are some fruitful paths.
It's been a really fascinating conversation, Kristen. Thanks so much. I think it's a new frontier, and I think you've opened it up to many people. You might have made some people worried, but that's not a bad thing. I think it's important to alert people to this technology, but also to focus on the positives and the opportunities that this type of technology presents. So thanks so much for sharing your insights and for unpacking this in an understandable way. And I think it's something that we all will have to watch and keep our eyes on. I think it's actually exciting, I think, for privacy professionals to see where this is going to lead, because this is the future. So as privacy professionals, we need to find ways to make the future compliant.
My pleasure. Thank you for having me today.
That's it for today's episode of Privacy in Practice, brought to you by VeraSafe.
If you enjoyed today's conversation, be sure to subscribe so you don't miss out on future episodes. And we'd love to hear from you. Send us an email to podcast@verasafe.com.
And to learn more about VeraSafe's data protection and privacy services, you can visit us at verasafe.com.